Hi, everyone, and welcome to our annual Federal Sector Update webinar. While I introduce myself and the speakers, I will turn your attention to the following slide. So we were very delighted to see a lot of really familiar names on the list of, I think it was over 500 attendees today. So thank you very much for joining us. For those of you who don't know me, my name is Jackie VanDerMeulen. I'm a partner in the Labour and Employment Group here in Toronto, and I am joined by my Labour and Employment colleagues, Stéphane Fillion, who is he's a partner in the Montreal office of our Labour and Employment Group. He's also the co-leader of the group, and my colleague Pigott, who is a partner here in our Toronto office. And very unfortunately, for reasons beyond his control, Derek Hines from FETCO is unable to join us today. But I did want to do a special mention to him at the outset and really thank him for his assistance in developing this presentation. I'm sure most of you know by now that he's a really important force in the federal sector, representing the employer community, and he does bring exceptional insight. We will do our very best to convey some of that insight to you throughout the course of the presentation, but he is certainly missed. I'll turn next, please, to the agenda. So, and I'm starting to sound a bit like a broken record on this front because I seem to make the same comment every year at this presentation, but it's been a very big and busy year for federal sector employers. This year in particular, there's been a lot on the legislative front, which is where we're going to focus the majority of our comments today. And I would say the legislative front, we're also going to try and tie that back to the bargaining table for those of you who are unionized employers, because obviously there's a sort of direct impact often on what happens there for you. So I will start by turning it over to Chris, who's going to begin the discussion on the proposed ban for replacement workers. Just a note about questions, that we will do our very best to try and address questions both throughout the presentation. There's a comments box that you can feel free to include your questions in, and we'll try and save some time at the end. From prior experience, we know that there tends to be so much to cover in these presentations that we don't have as much time to get to the questions. So please, if we don't get to your question, feel free to email any of us afterward. We see the questions themselves as they come through, but we don't see who's actually sending them. So we won't be able to respond to you directly unless you actually reach us by email. But of course, we're happy to connect on that front. So without further ado, we'll turn it over to Chris.
Jackie, thank you. And good afternoon, everyone, and welcome. As Jackie mentioned in her opening comments, it really has continued to be a torrent of legislative activity from the Trudeau government in respect of labor, employment, and human rights issues. I think many of us over the past few years would have thought that after 2019, 2020, this government would have been tired, but it does not appear to be yet on the labor front. One of the biggest proposed changes that we have seen is a proposed ban on replacement workers within Part 1 of the Canada Labour Code. This ban emerges from the Liberal NDP Supply and Confidence Agreement, in which the NDP agreed to support the Liberals, the Liberal minority government, through 2025. This agreement was reached earlier this year in March 2022. The proposed ban on replacement workers is set out in one very short and, in my view, quite vague paragraph, which you'll see up on the slide, which says, we commit to introducing legislation by the end of 2023 to prohibit the use of replacement workers, scabs, when a union employer in a federally regulated industry has locked out employees or is in a strike. So the proposed ban would cover both locked out and struck employees. But that is all we know about the proposed legislation based on the Liberal NDP agreement of earlier this year. So we have been left guessing a bit about what the proposed ban to come in before the end of 2023 could look like. We do know, however, what the current landscape looks like. So what do we have in the current Canada Labour Code? Well, there is a very limited prohibition on replacement workers in Section 94 of the code. Many employers do not even know this prohibition exists. And that is because in practice, it comes into play so very rarely. And Specifically, the current prohibition on the use of replacement workers only applies when an employer is using replacement workers for the specific purpose of undermining a trade union's ability to represent its employees. The Federal Labor Board has been quite clear that this is a really high bar. An employer is allowed to use replacement workers to put economic pressure, including significant economic pressure, on a trade union in the bargaining context. That's very clear. So an employer is allowed to use replacement workers to gain leverage at the table. What it's not entitled to do, is go several steps further and use replacement workers for the purpose of really destroying the union's ability to represent employees at all. And in particular, where there's evidence that the employer is using replacement workers to try and get employees to ultimately decertify the union or otherwise try to get the union out of the workplace. That's when you verge into the territory of prohibited activity that's covered by the ban in Section 94 of the Code. Significantly, the onus is on a union to demonstrate that an employer has gone that far and tried to undermine the union. It's a very high evidentiary bar to cross. So I'll say it again, this prohibition has come into play very few times in practice since it came in the late 90s. Next slide, please. What do we know about the changes to the current landscape that we might see? Well, Minister O'Regan has just announced within the last month the beginning of consultations that are ongoing to adopt the legislation that would prohibit the use of replacement workers by the end of 2023. The consultations are ongoing. They're taking place up until December 16, 2022. And at this point in time, we know that there have been meetings scheduled, some public meetings, some private meetings with employers and unions, at which government representatives will be engaging with the parties to talk through what the scope of the prohibition might look like. In support of the consultation, the government did release a discussion paper that provides some background on the use of replacement workers in the federal sector and elsewhere, and poses some questions to employers, unions, other interested stakeholders on a proposed ban on replacement workers. The questions in the discussion paper are quite open-ended. Unfortunately, other parts of the discussion paper, some of the preliminary conclusions that appear to have been reached, and certainly the fact that the discussion paper opens by noting that the Liberals and NDP have committed to introduce a ban on replacement workers, suggests that this consultation is really leading towards a predetermined outcome. And the only question is now, what will the details of the much broader ban on replacement workers be? So that's the key question as we see it in the consultation process, at least on the surface. How broad is a prohibition on the use of replacement workers going to be when that legislation comes into force by the end of 2023? So we don't know a lot about what the federal sector could look like next year, but we do have some examples from the provinces as to what a ban on replacement workers could look like. There are currently 2 provinces that have prohibitions on replacement workers: British Columbia and Quebec. I'm just going to spend a moment talking about British Columbia before I kick it over to Stéphane to go through the current situation in Quebec. BC's had a ban on replacement workers since 1993. Specifically, amendments to the code have since then provided that the use of prohibited replacement workers is going to constitute an unfair labor practice. The code sets out very detailed rules on who can work during a strike or lockout and who cannot work on a strike or lockout. And they're quite complicated. I'm going to go through the key points for you. The first key point is that The prohibition applies to both paid and volunteer workers. So you cannot get around the prohibition by using volunteers or trying to structure their compensation in some way so that you can say that an employee is not being paid to work during a strike. Second, there's quite a broad category of prohibited workers in British Columbia. Go through the key ones. First, anyone who was hired after bargaining has begun cannot work during the strike or lockout. Second, an employee or manager who normally works at another location cannot be moved to the struck or locked out location to perform bargaining unit work during the strike or lockout. Third, someone cannot be transferred to a struck location who was transferred to a struck location after bargaining began. So before a strike or lockout happens, but after bargaining began, that employee also cannot work during the dispute. And last but not least, any individual who's provided by another person, so an agency employee, a contractor, anyone, any third party who is seeking to work at the struck or locked out workplace, that person is also prohibited. The code also allows any person to refuse to do the work of a person on strike or lockout, and prohibits an employer, and this isn't surprising, prohibits an employer from taking disciplinary action against anyone who decides not to work during the labor dispute. There are really two main exceptions in BC that may be relevant in the course of the federal consultation. The first is that the ban on replacement workers does not apply to employees who were in the bargaining unit that's affected but wish to work. Employees in that category can work during the strike or lockout. Second, it does not apply to prohibit employees who work at the same location as the striking or locked out workers, but work at the same location. Those employees, so that no transfer has taken place, those employees are allowed to serve as replacement workers. So the practical effect of this is that an employer in BC can use managers at the same location as replacement workers. But interestingly, and the BC Labor Board has some case law on this, the employer is not allowed to just go out and hire more managers or do promotions and backfill employees so you build up your management complement during a strike. Rather, you're really stuck with using pre-existing managers at the struck or locked out location as replacement workers. So British Columbia is the first example that the federal discussion paper for the consultation pointed to as a possible template. The second, as I mentioned, was Quebec. Stéphane, I'll throw it over to you to talk a bit about Quebec.
Thank you, Chris. I'll try to highlight it as we go along as well, the differences with British Columbia. Maybe as a mean to kind of explain how we came about this provision. It was actually enacted in 1977, so we have a very long experience on the application of these provisions. And as I was growing as a lawyer with my former firm, Ian Blakey, I was often reminded of what led actually to these provisions. And I think it's important when we start talking about what's the reasoning behind what the federal government is doing. At the time, it was based on a couple of pretty violent labor conflicts that took place in Quebec. One of them where we were involved at the time was United Aircraft, that some of the older people listening today might remember. Basically, the company was using replacement workers, and the lockout lasted 22 months. And basically led to all sorts of violence, police intervention on repeated occasion. So it was kind of the idea of, we're going to set up some rules against replacement workers so that we're going to reduce violence on the picket line, which doesn't seem to be the same idea behind the current legislation. So anyway, let's go down to what applies in Quebec in that regard. So the first element is a person hired between the day the negotiations begun and the end of the strike or lockout to perform the work of an employee member of the bargaining unit then on strike or lockout. It must be, it is not mentioned specifically in there, but this is in the establishment on strike. So that's in relation with the violence thing that I was mentioning initially. So just so you understand, what kind of limitation this imposes. Chris mentioned that in BC, for example, you cannot hire new managers during a strike or after the negotiation period has begun. It's the same thing in Quebec. The only difference being that you can promote employees who are already working for the employer even before the negotiations begun. So that's one thing we have that might be better than what you have in BC. Just in terms of the impact it could have, just think about most of the times when you have a long labor conflict. As we go along, a lot of managers will tend to resign, leave, or get sick. And obviously that means you cannot replace them. So as you move along during a labor conflict, you will necessarily have to reduce the operations that you were maintaining in the beginning. So second one is a person employed by another employer or the services of another contractor to perform the work of an employee member of the bargaining unit, then on strike or lockout in the establishment where the strike or lockout has been declared. So again, same thing as I was mentioning earlier, the idea of making sure there's less violence on the picket line by not having people who basically cross in front of the employees on strike. So that's a second important aspect. Third one is an employee who is a member of the bargaining unit on strike unless an agreement has been reached for that purpose between the parties. This is something that I found weird when I was preparing for this presentation. So in our case, obviously, employees who are on strike cannot come back to work in the meantime, whereas in BC, they could actually, which probably makes it for very nice relationship between coworkers when a couple of them decide to cross the picket line and come back to work during a strike or lockout. But anyway. Third one is an employee who is a member of the bargaining. Fourth one, an employee who is a member of the bargaining unit, then on strike or lockout in another of his establishment. So in other words, you can't use employees who are on strike or lockout to work either at the facility that's currently in the labor conflict or in another establishment for the same reason that I mentioned earlier on. The one thing that I could say that is, let's say, positive is we do not have a similar provision like you saw in the BC code where employees have the right, and it's employees, including managers in BC, have the right not to do the work that is required of them. So in other words, in Quebec, if there's a contingency plans, managers will not have the option of saying, no, I don't want to do the work of the employees who are on strike or lockout, unless obviously they decide to leave. One thing that I also wanted to bring up to everyone's attention is I mentioned on a couple of occasions the fact that it needed to be in the establishment where the strike or lockout has been declared. When you start with a replacement ban, you know where you're starting from. You don't necessarily know how it's going to end up. So I wanted to mention that although it says in an establishment, it hasn't been interpreted pretty much several years ago as including, for example, for a truck driver, the road he's using to go from one facility to another. So in other words, this was interpreted as being the establishment of the employer. And more recently, in the context of remote work, the house of some employees was also considered the establishment of the employer, given that it's kind of an extension. Obviously, that goes well beyond what it was supposed to be at the beginning. So it's kind of something to keep in mind when we're discussing the replacement ban at the federal level. We know where we start. We don't necessarily know how it's going to end. Next slide. So three other elements that are prohibited. So an employee employed in another establishment to use in an establishment where strike or lockout has been declared. We're not talking about a manager here because it's already covered by another prohibition. A person other than an employee employs in another establishment except where the employee of the latter establishment are members of the bargaining unit. So we're talking about you cannot bring supervisors from another establishment in an establishment on strike to do the work unless their own establishment is also covered by the same strike. And finally, an employee he employs in the establishment to perform the work of an employee member of the bargaining unit, then on strike or lockout in an establishment where a strike or lockout has been declared. One final note, when we're talking about, you probably saw the difference between person and employee. Person is intended to cover managers. Employee the employee has been interpreted very, very restrictively and only covers managers, not non-unionized employees. So in other words, if you compare it to what we saw in BC, an employee who's not unionized, let's say kind of an office employee, cannot work during a strike in Quebec like it would in BC. Next slide. So in summary, the prohibition on the use of replacement workers has two main exceptions that we see when this happened. So the management of the striking establishment, if they have been hired prior to the date that negotiations begun. And finally, the very exceptional case of preventing the destruction or serious damage to the employer's property. Next slide. So do you want me to turn it back to you, Chris, or make a couple of comments?
You can make a few comments.
Okay, so I thought I'd kind of jump in. I also read the discussion material that Chris mentioned at the beginning, and as he was mentioning, the whole deal in and of itself, but plus the way it's drafted. If you read the discussion paper that are available, make me particularly worried. It really looks like there's no. It's not like an open discussion where it could end by there's not going to be a replacement worker ban, and that concerns me for several reasons. First one is why exactly is that being necessary at the present time? I've been working with federal employers for a long period of time, and how many lockouts have there been? How many strikes where federal employer have been using replacement workers, let's say in the recent 5 to 10 years? Not many. In most of the cases, federal employers are pretty big in nature, given the nature of their activities. It's not easy to replace workers. There's all sorts also of security elements that make it almost impossible to train employees in sufficient numbers in order to perform the work of the employees who are on strike. So why exactly are we talking about this now? Maybe except the fact that obviously it came with a deal with the NDP at the beginning, but aside from that, I have a hard time understanding what exactly is behind this. I also wanted to raise the new issue that we're seeing right now in collective bargaining, and that is the impact of the manpower shortage in the market. We see now something, there used to be a time where workers who would go on strike would receive indemnities from their union, which would be kind of minimal compared to what they were making before. So you could have someone who was making previously $800 a week, now making $200 on the picket line. So obviously there's a big incentive in somewhere along the line going back to work, because obviously you're losing money every week. But the situation has changed. I've seen, obviously it might not apply to very high paid employees, but when we come down to employees who are kind of more on the average side, they can easily find jobs, and they actually do. So imagine you have a worker who was making $25 an hour. They go on strike. He finds another job at another employer at $26, $27 an hour. What's the incentive in coming back? Have we ever talked about, limiting employees' right to start and go work for other employer? Never, because that would obviously be kind of preventing them from earning a living. But we seem to be very okay with the other way around, even if there's no justification, especially in the current context, to do that. So I'm keeping my fingers crossed. I know how much FEDCO has worked in these files, but I think there's a kind of a tough hill to climb.
Stéphane, I think that's right. And, to summarize what I think you've just said, this is, to me, like a solution that's looking for a problem that doesn't exist. There doesn't seem to be a real problem with the use of replacement workers. And frankly, there doesn't seem to be a significant power imbalance as between employers and unions in the federal sector. And I think many in this webinar might suggest that the power balance actually already tilts to a lot of the unions in some federal sector workplaces, given the nature of the workplace. And this is why I think that there is reason to be worried. The consultation paper does appear to set up a pretty binary choice here between, BC, Quebec, what elements are we going to take from these models and try to import in the federal sector to fix this problem we have? And the challenge becomes that you may end up creating a problem. You may end up changing the current power balance. You may end up contributing to more and longer strikes because you have unions and workers who feel quite emboldened by this new prohibition. Where replacement workers are used, what's the impact they're going to be, given that many federal sector employers really do constitute a part of the national infrastructure. One concern that I have is that this may inadvertently cause an increased need for back to work legislation. This is a federal government who, despite saying it doesn't like back to work legislation, has certainly used over the course of the past few years. Are we going to need to see more of that going forward? And so that's all to say, this could create a problem that doesn't currently exist. And that's one of the reasons why the ongoing consultation process is very important. I know that if Derek were here, he would probably mention how active FETCO has been on this file, really since the NDP Liberal Agreement deal was announced in March 2022. I know FETCO continues to be very active in the consultation process. And to my mind, this consultation process, which again goes up till December 16th, really is the last opportunity, or one of the last opportunities, to try to convince the federal government that, one, the status quo was fine. There is no reason to rock the boat right now. But if that message cannot be transmitted to the federal government in a way that actually maintains the status quo in this area, hopefully the federal employer community can at least ensure that any changes that are made are minimal, narrow, and carefully tailored, and don't have inadvertent complications that create problems, as many federal workplaces go into big rounds of bargaining over the next year or two in very uncertain and interesting economic and inflationary times where the content of bargaining is going to change. Bargaining dynamics are already going to change. This is probably a wrench that we don't need to throw into the works at this point in time. So that I think, to summarize, to say that please pay attention to the consultation process. It's important, and we'll try to keep you updated on this front as things unfold.
One last comment, Chris, if you allow me. You might remember that when we started this process, when we first started hearing about the replacement workers ban, there were talk about limiting it to lockout and not include strike. Obviously, this has changed, but perhaps if it ended up being, adopted anyway, maybe there's something to be done as well on that front.
Very good point. Okay, turning to what I wish I could say was a happier topic, but I think for many employers has been an even more indigestion-inducing one, is the new paid medical leave under Part 3 of the Canada Labour Code that we know most federal employers have been watching very closely over the course of the past just over a year since it was first introduced in Parliament. What is the new paid medical leave? Well, it really has the following key features, which, frankly, we've tried to distill from a fairly confusing piece of legislation. The bottom line benefit is really as follows. After 30 days of continuous employment, an employee covered by Part 3 of the code becomes entitled to 3 days of paid leave to use for personal illness and injury and several other medical purposes, such as visiting, going to doctor's appointments during working hours, donated organs, and quarantine. So that's 3 days of paid leave earned after 30 days of continuous employment. Thereafter, the employee earns 1 more day of paid leave each month. And that earning process maxes out at 10 days of paid leave per calendar year. So in theory, your typical employee who's working full-time, part-time, or casual basis, but on a permanent basis, is going to be earning up to 10 days of paid leave per calendar year. This entitlement comes into effect on December 1st, 2022. And the practical impact of that is that employees who are currently employed are going to be entitled to 3 paid days off as of December 31st of this year. So this is a big change. This is a big change. We're going very quickly from a world in which there's no paid medical leave entitlement other than the minimal personal leave entitlement under the code to one in which employees are going to have an additional 3 paid days of leave as of December 31, and then be earning a further day each month, up to 10 per year going forward.
Chris, can I just jump in on that one? Because I know there was a lot of confusion when the regs first came out on this front. Do I understand correctly, this is irrespective of the size of your workforce?
This is irrespective of the size of your workforce. So there was, and it's a very good question, Jackie, there were provisions in the legislation which would have exempted smaller employers for a period of time. But actually, after some updates were put out there, we were advised by the government and government representatives that they did not intend to proclaim and to force those exemptions for small employers. And so, as of December 1st, just 2 weeks from now, this entitlement is going to apply across the federal sector, across all federal workplaces. What else do we know about the new paid medical leave benefit? Next slide, please, Andrea. Well, what we know from the labor program as it stands is that all employers are going to need to provide that 10 paid days at 100% of wages, full stop. So if you have an existing STD program that provides 75% wages or something like that, the labor program's guidance, at least, is that won't be sufficient. You have to be providing 10 days paid at least 100% of wages. Okay, so that's the current guidance we have. That gives rise to the big question on many employers' minds, which is how does this new statutory entitlement interact with existing leave entitlements? And those are existing leave entitlements, whether it's in an individual employment contract, a collective agreement, or something like a short-term disability program that an employer's been providing to employees to date. How do all those existing benefits overlap with the new statutory medical leave? And my view, at least, is that it's just not clear yet. This is for a couple of reasons. First of all, the legislative changes to Part 3 of the code, so the actual changes to the legislation itself, did not provide any real clarity on issues like greater right or benefit, or how benefits, quote unquote, stack on top of each other. Requests were made to the federal government by federal employers to include some sort of specific greater right or benefit provision, or other legislative exemption that said if we already provide a generous sick leave entitlement or short-term disability entitlement to employees, we don't also need to provide this new 10 paid days. But no changes were made to the legislation in response to those requests. What the legislation does include is an ongoing regulatory authority that allows the government, cabinet, to pass regulations that exempt certain classes of employees or employers from all or part of the requirement to provide 10 paid days of leave. We did have regulation come out just last week that I think many employers hoped would provide some clarity on stacking or greater rider benefit, but unfortunately the regulation did not touch on the issue. What the government did do, however, is issue an IPG at the same time as the regulation. An IPG is an interpretation policy and guideline document that the labor program puts out, and they're available on the labor program's website, to provide guidance to employers, unions, employees about new entitlements. These are non-binding documents. They do not have legal force. In some situations, arbitrators, adjudicators will consider the IPGs and rely on them, but they're not required to, and indeed, in many cases, they disregard or modify the approach taken in an IPG. But we do have an IPG that provides some non-binding guidance to us. To my mind, the IPG still leaves a lot of questions to be answered. And in fact, it may raise more questions than it answers around greater rider benefit and stack. This is for a couple of reasons. Well, first of all, it's very clear that the IPG is, as I mentioned, non-binding. And the government actually went so far as to say explicitly that this IPG is not meant to change the law. It's really just meant to reflect the existing law in this area. The problem is that there actually isn't much law at all in the federal sector in this area. There has been virtually no litigation in the federal context around greater rider benefit on Part 3 entitlements. It's because they weren't that generous, certainly weren't as generous as most collective agreements until the last couple of years. So there are only a few cases out there. And those cases go a couple of different ways. And so the law really isn't clear. So the IPG, to my mind, doesn't really clarify the law here. Second, the IPG, I think, is internally inconsistent in some respects. Again, IPGs are not legal documents. They're usually quite short. This one is, I think, 7 to 10 pages. The problem that arises sometimes is that, the IPG will say something in one section that is tough to square with another section. In this IPG, one of the prime examples that comes to mind is that early on, it says that where an employer provides a less favorable benefit than 10 paid days off, then employees get both the existing entitlement and the full new 10 paid days off. So that means that if employers, say, provided 5 paid sick days at 75% of wages, in theory, an employee is now entitled to that plus an additional 10 paid days. The problem becomes that later in the IPG, there are a few examples that deal with less favorable benefits, but they then go on to say that the employees in those situations are not entitled to either all or part of the new 10-day statutory entitlement. So it's issues like this, inconsistencies like this within the document that raise questions that to my mind at least, remain unanswered. And last but certainly not least, one of the glaring gaps, I think, in the IPG and in this sort of discussion more generally to date, is what do we do with the modern short-term disability programs that many, if not most, federal employers offer their employees, both non-unionized and unionized? These are, as most of you know, these are pretty standardized schemes that have been developed over decades, including through negotiations, that don't just provide a flat number of days, at 100% of wages. They often provide less wages than 100%, but may extend for a significant period of time beyond 10 days. We don't know how to deal with these schemes in the context of the new statutory entitlement. And so unfortunately, there are a lot of questions that are left to be answered. And so where does this leave us? Well, we have December 1, 2 weeks from today, just over 2 weeks from today. That's when this new legislation comes into force. And I think that my experience, at least, has been that a lot of employers are still trying to come to grips with how to comply with the new requirement. How do we bring our existing scheme into compliance with the new 10 paid day requirement? Or do we need to make any changes if we already offer a very generous medical or other type of leave that could be used by employees in this situation? Unfortunately, I think that there's lots of litigation to come in this area. I think we've seen many unions in the federal sector say that their expectation is that, existing entitlements really don't come into play. They want the full 10 paid days or something pretty close to that. Employees also have expectations too, because these have been quite highly publicized by the government. So that, on the one hand, is a force that is expecting a generous new entitlement to come into force just weeks from now. On the other hand, you have employers who already offer generous compensation schemes to employees, uncertain economic times, and no real guidance on what they're required to do to bring their existing schemes into compliance. These two forces are coming together, and I think you're going to see lots of litigation on this front over the next year or two. The costs associated with introducing a benefit of this scale are huge for employers, to say the least, for some employers. And I think it's very tough to make decisions to increase your costs so significantly in the absence of really clear legal guidance on what to do. The other thing, and Stéphane, Jackie, you may have thoughts on this. The other thing that I think we'll see is a real need for unionized employers to try to deal with the new paid medical leave entitlement in collective bargaining. A lot of bargaining is coming up across the federal realm. And I have to think, and I know that many federal employers feel a need to try to figure out how they incorporate the new entitlement or address the new entitlement in the context of their current collective agreement and current total compensation package. And so the dynamic in bargaining, to my mind, is going to be preoccupied not just with inflation and wages and things like that, but how do we deal with the structural changes that may be necessary to deal with statutory medical leave? Jackie, do you have any thoughts on this, Stéphane?
No, I mean, I agree with you. Oh, sorry, go ahead, Stéphane.
No, I was letting you go, and I'll make my comment after.
I think that's exactly the issue, though, is like how are employers going to wrestle with this issue when their backs are a little bit up against a wall? The unions know to a large extent they've got other avenues to pursue these leave entitlements. So there's less of an incentive to sort of give on that front in bargaining, but it's certainly open to employers to come up with creative solutions to try and get their proposals through.
Maybe a couple of comments. So I was involved a lot when the personal days came in, because I do personally a lot of collective bargaining. And as you were mentioning, Chris, there hasn't been that many litigation so far. And I think that can be explained. Obviously, a lot of collective agreement had provisions in them that provided for, some form of either sick days or floating days or personal days or things like that. And even when it didn't, the code was 5 days 5 days in total, but 3 days with pay. So it was easy to come very close to this situation. So even some employers decided, you know what, I'm just going to grant the 3, or some of them made a mix of saying, you know what, my leaves are already covered, but the number was not big enough that it led to a lot of litigation. It's kind of contrary to the experience we had in Quebec, because pretty much at the same time, the Quebec government introduced a 2-day sick or family obligation day. So it's 2 in total, whether it's for sickness or family days. And there were a lot of litigation, and we were kind of pretty optimistic because most Quebec courts took the position that if you had floating days in your collective agreement, this was necessarily a greater benefit because you could take a leave even without being sick. So it was better than just having a leave for sickness. But that was not the position we saw in the very few decisions that have been rendered under federal law, where it was more a question of, was this intended to cover sickness? Was this intended to cover these type of leaves? And the reason why I expect that this time there will be lots of litigation to come, as you were mentioning, is because of the size, the number of leaves that we're now seeing. Just to answer as well, one of the questions that was raised on the chat, yes, you keep the 3 personal days plus the 10, or the 5, depending if you want to take the total personal days. The only thing we've removed from personal days now in the code is the sickness aspect of it. But in theory, an employee could be absent for 15 days, 13 of them paid if you count sickness and personal days. So obviously that number is so high that there's going to be a big incentive on both sides to go to litigation on this one. It's going to be very hard for an employer to have as many leaves in their collective agreement, so enough leave in their collective agreement to argue that they had a greater benefit. Maybe there's going to be some exceptions, but this is why I expect there's going to be more than that. One of the element that you mentioned, Chris, that I think is interesting and I've been wondering for a lot of time, what if I offered short-term disability paid at 75% for the first day for the first 6 months? Is that a greater benefit than 100% for 10 days? That's just a question that has not been answered so far, but I'm really expecting that there's going to be litigation. The other thing that I'm seeing when I'm trying to negotiate for new provisions is, they never make it simple. Anyone who has looked at the legislation, like the first bill and then C-19, which included the 100 employees thing, and then another bill, and everything is kind of referring to another number. Everybody's having a hard time understanding exactly what is covered. Even us, like, we have to read it like several times in order to understand what exactly is covered. So how will unions and even employers at the internal level be able to work with this? So that's another reason for litigation. The third problem that I'm seeing as well is, we've all seen, as you mentioned before, that it's 3 days and then you accumulate 1 day per month until you get up to 10, and you can even have your accrual that you didn't use in the first year used in the second year. This is very rarely compatible with what was in place at employers. So as you were mentioning, I think that it's going to lead to a lot of collective bargaining, reviewing the leave, and setting up almost like a new system, unless you're willing to pay and to stack leaves on top of the existing one.
Hi. Stéphane, should we turn it over to you for French language discussion?
Yeah, so I'll try to be relatively brief, because I know it doesn't apply to all employers, but it applies to more employers than one would think. So that's another interesting, if I can call it like that, interesting development. So French language in the workplace. It all started with the amendment of the Quebec Charter that came into force about 6 months ago, and that introduced a lot of amendments to the Quebec Charter, one of them being the provision that you see on the screen. So section 89.1, which says no provision of this act may be interpreted in such a way as to prevent its application to any enterprise or employer carrying on its activities in Quebec. Although it doesn't mention it specifically, the idea with this clause was to make it clear that it would apply to federal employer having operations in Quebec. It was also supported by a unanimous motion that was adopted by the National Assembly, so all parties, supporting the idea that it should apply to all federal employer. Just to maybe, without getting into a constitutional debate here, I have a hard time believing personally that the language of work provision could apply to an employer under federal jurisdiction, but we've been surprised over the years by sometimes the decision that have been rendered at the highest level on this. I just thought that, in terms of interference, setting up for federal employers the requirements in terms of language for their employees looks to me to be pretty interfering. And there's also the old question of recourses that we're going to be talking about for employees who could be subject to dismissal, for example, or refusal to hire. So anyway, that will be something that will have to be followed. That being said, it's all a question of what employer will want to take this fight anyway. Given not only the cost of the recourses, so getting to the Supreme Court is nice, but obviously it's also costly, and most of the time it comes with a public relations nightmare. So it remains to be seen how many employers will really choose to make this battle. That's probably what the Quebec government is counting on, especially given that a lot of federal employers have already applied the general principle of the Quebec Charter anyway. Next slide. But anyway, the federal government came with its own draft bill to deal with French language in the workplace. So that's Bill C-13, for those who were not aware of it, which is called the Use of French in Federally Regulated Private Businesses Act. So obviously the federal government is not of the same view as the Quebec government. The government instead believed that it's Bill C-13 that will apply to federal jurisdiction employer. So again, this could lead to a constitutional challenge in the future. But as we will see, Bill C-13 includes several provisions that are similar to those of the Quebec Charter. So it could be limited in terms of recourses. Next slide. So this bill would grant new rights to employees and consumers in Quebec, but you've probably noticed that it's not mentioned Quebec in the name of the legislation, and this is because Bill C-13 proposes to apply to any regions in Canada with a strong Francophone presence. We'll see the criteria later on. So in other words, it's not just interesting for employers who have operations in Quebec. It's also interesting for those who could have operations in regions where there's a strong Francophone present. It would recognize, as it says, the right to work in French and the right to receive communication and services from federally regulated businesses in that language. In terms of timing, we obviously have no date for now. It only says that the provisions relating to the Quebec side could come into force on a day fixed by order, but the provisions for regions with a strong Francophone presence would come into force 2 years after the date of this order. And that will be necessary because for now, we don't know what exactly is a region with a strong Francophone presence. The only thing we know now is that in the regulation that could be adopted to cover that, the government could take into consideration factors like the number and proportion of French speakers in a region or the vitality and specificity of its French linguistic minority communities. Next slide. So let's look over, who it would apply to and some of the provisions. So it would apply to most employers. The exceptions being those who are already subject to the Official Language Act. Those with fewer employees than a number provided by regulation. Don't ask, we don't know what the number could be. Unfortunately, we'll certainly find out eventually. And it also excludes employers whose activities or workplaces are relating to the broadcasting sector. That's also interesting why exactly this was excluded. Maybe it's because obviously there are some entities in the broadcasting sector who, are the English language. So that might explain why they're excluded, but that could also be true in other areas as well. Next slide. What obligations are currently included for employers? So 3 main obligations. First one, promote the use of French. Doesn't say more than that. Inform employees of the application of Bill C-13 and their rights and remedies. The third one, which is kind of less interesting, is to set up a committee to support senior management in promoting French and its use. It's still better than what we have with the recent amendment of the Quebec Charter, where it says that it must be a minimum of 6, half of them being selected by unions, or if there's no union, elected among the workers. So obviously now there's no mention of how it's going to be set up in terms of who's going to be part of the committee. So employees would have the right to carry out their work and be supervised in French, receive all communications and documentation from their employer in French, including job offers, promotion notices, notices of termination, and collective agreements. This is already the case for most federal employers in Quebec anyway, given the nature of the market. It also says that if a document is written in French and English, the use of French must be equivalent to the use of English. Employees are also entitled to use work instruments and computer system in French. So that's basically the initial obligations. Next slide. It also prohibits the unfavorable treatment of employee who holds a position on the ground that they do not have sufficient knowledge of a language other than French. That's kind of the standard provision that you find also in the Quebec Charter. There's an acquired right provision. So in other words, if an employee was hired before Bill C-13 comes into force and doesn't have a sufficient knowledge of French, it cannot be sanctioned for that reason. The one thing that generally causes the most issues in Quebec is the last one. So an employer can require an employee to know a language other than French only if it can demonstrate that knowledge of that language is objectively required by the nature of the work to be performed. So you can imagine that this leads to challenges on several occasions. But again, it's still better than what we currently have with the Quebec Charter, where we now have a new provision that states that you must not only have this reasoning, that demonstration, but you must also include the demonstration, so at least language about that in the job posting itself, explaining why you're asking for another language than French. And you must also make this demonstration now under Quebec law based on the composition of your workforce. So just to give you an idea, if you have 20 people working in a call center and they all speak both language, one of them leaves, you want to replace them with someone who's going to be fully bilingual. While in Quebec, you'd have to demonstrate that the 19 other people who speak English could not do the job. So allow the last person to only speak French if needed, even if you needed to reroute calls so that the person would not be asked to answer people in English. So you can imagine what that could mean. Next slide. The employee recourses, I'm not gonna cover. You kind of have the basic idea that there could be recourses similar to what we have under the Canada Labor Code. Next slide. The powers of the board, because the board will ultimately be responsible for that. So the Canada Industrial Relations Board, so all the powers that you would have for any kind of unfair labor practice already covered by the code. Next slide. The one slide that I wanted to cover in a bit more detail is how it interacts with the Quebec Charter. So again, I mentioned in the beginning that the Quebec government believes that the Quebec Charter already applies. Bill C-13 takes a different approach. It says instead that federal employers can decide to be subject to the Quebec Charter if they want to. So in other words, they would have to make a notification stating that we want to be covered by the Quebec Charter. And if that's the case, Bill C-13 would not apply to these employers. However, the employer would still be free to give a notice later on and decide to cease to be subject to the charter by giving notice to that effect. I understand that for some employers might be interesting to do because most of them in Quebec already follow the general principle of the charter, but I've already entered that Bill C-13, at least in the way it's drafted right now, is less stringent on employers than what we see in the Quebec Charter. The other one is especially if for employers who have operations across Canada and maybe in other regions where there's a strong Francophone presence, might be harder to have rules that would differ in Quebec than what you would have in these regions. So a lot of fun for the coming years.
Thanks, Stéphane. I'll turn now to some other legislation that, and you've heard me speak about these legislative reforms before, so I'm going to sort of skip over the broad overview part of the session and instead really get into sort of what we're seeing now and what the practical next steps are for employers. So next slide, please, Andrea. I'll start with the Pay Equity Act. The Pay Equity Act is in force. And essentially, again, it's a proactive regime that requires employers to proactively look at their pay practices and identify and subsequently correct any wage gaps that they see. It's the focus really is on equal pay for work of equal value. So it's not an individual analysis. It's looking at systemic pay discrimination based on gender that's built in to society more broadly and trying to put the onus on employers to correct those societal forces. Next slide, please. So employers who have 100 or more employees or who have unions in their workplaces are required to do this exercise in committee. Oops, and there's a box there missing, but essentially that's going to be a really challenging part of this whole process for a lot of employers. And I know a lot of employers are struggling with that now, how to set up the committee. The requirements for the committee structure are prescribed by the Act. And again, I won't get into detail, but it's referenced there for you. And for employers who don't have the 100 more employees and don't have unions, it doesn't mean you're off the hook. You still got to do this exercise if you've got 10 or more employees in your workforce, but you don't have to do it in committee. You can do that work unilaterally instead. Next slide, please, Andrea. What does that committee have to do? Or if you're not subject to the committee obligations, what do you have to do? Well, it's a very prescribed list, and don't let the 8 bullet points fool you. This is a lot of work. Under each of those bullet points is a whole host of analysis and really decisions that ultimately have to be made by the committee or by the employer in conducting the pay equity exercise. You see that 3-year timeline there. We're already a year and a bit into that. And certainly there's still a lot of work for most employers that we're working with are really just in the infancy of developing their strategy on this front. Which doesn't mean they haven't been working on it for a year already. It's just that there's really so much to do in terms of getting prepared. Next slide, please. Because this is where I really want to focus is sort of what are we seeing right now and what are employers actually doing? So a lot of employers are still working on the sort of current state assessment. And what are they doing in that process? They're looking at their data, they're cleaning data. It's amazing how challenging it is for federal sector employers, many of whom have tens of thousands of employees, to get clean data and to have really the data that's needed to actually do the exercise. So there's a lot of work being done on that front. You'll have seen on the prior slide that part of this pay equity process is also looking at job evaluations. You've got to be able to value the work to be able to do comparisons between job classes of equal value. That job evaluation process is very complicated. It can take a long time. Some employers have existing systems in place and they're updating those systems, making sure their assessments are current. Others are really starting from scratch. Ultimately, it's going to be the committee who makes all of these decisions if you have to have a committee in place. So employers are sort of weighing whether they go ahead and do some of that work in advance in the hopes that the committee will adopt their job evaluation methodologies, or whether they just sort of hold off and do that work in the committee. So you can imagine how much work that's going to be. And we know that for those employers who are unionized, the unions have already come out very strongly in saying that they're going to require employers to have very tailored job evaluation methodologies. So if you've got an existing job evaluation methodology, let's say that you use for your non-unionized employees, it's probably a fair assumption that the unions are not going to be willing to accept that job methodology. A lot of employers have like a hate points-based system, for example. Unions are pretty clear for the most part that those kinds of systems are not going to be applicable, or they're not going to support the adoption of those systems on their workplace. So just keep that in mind as you're going through. We're also seeing a lot of employers do what we call mock pay equity exercises or ghost analyses under privilege with legal counsel to ensure that those analyses aren't later sort of producible, but to really do a risk assessment and figure out where potential liability lies, and are there things that they can do to sort of clean up their pay practices in advance or formalize existing pay practices to better align with the Act to try and minimize that liability. We're seeing a lot of action now on the multiple pay equity plans front too, particularly for unionized employers. Very few non-unionized employers, at least in my experience, are going the route of applying for multiple pay equity plans, but most unionized employers are, again, largely based just on the fact that the compensation structures applicable to unionized employees are tend to be quite different. The working conditions also tend to be quite different. And back to that point about a common job evaluation methodology, it may not be appropriate to have the same job evaluation tool used for your non-unionized employees who might be working out in the field or have very harsh working conditions compared to your office employees. So all those sorts of things are driving a lot of analysis on this front. Most employers that I'm working with are right now in the analysis stage where they're looking at the tests that are set out very explicitly in the Act and saying, okay, how do we meet the tests in the Act? One of the branches of the test is whether there are enough predominantly male job classes across all of the proposed plans. So that's like a data analysis exercise where you've got to go through and do that. So a lot of work to be done there before you even get to the stage of applying for multiple plans. Employers are also fairly active right now in trying to engage with their unions or other, if they have non-unionized employee representatives as well, to understand, are they going to be supportive of a multiple plans application? And if not, are there tweaks that they can make to get that support? A few unions, including PSAC, have come out and said, basically, no way we're supporting multiple plans under sort of any circumstance. A lot of the large national unions as well are, again, taking a sort of national position, and they're not necessarily letting the local bargaining units make decisions on this front. So just a warning there that you may be subject to resistance, even though from a local level, it makes a lot of sense. But some employers are actually having some success in bargaining as well. So for those of you who are involved in this process, you'll know that if you have a statement of support, or you have statements of support from your union representatives and non-unionized employee representatives, you can kind of be put in this fast track process for your application for multiple plans. And so employers are looking at ways to engage with unions to essentially get their commitment to the support, potentially in exchange for other commitments. For example, the size of the committee, the number of union representatives that will be on that committee. So lots of creative ideas going through on that point. But a point to remember is that you can't do the pay equity exercise itself in bargaining. It's a statutory process that's going to be, it can't be done within the confines of a collective agreement process. Have we seen applications for multiple plans actually go through yet? We know that there are a few that are sitting with the commissioner right now. And for those of you who didn't hear, Karen Jensen, who was the prior pay equity commissioner, she's been appointed to the bench, which is wonderful for her. It's a little bit sad for the employer community because I think we had a lot of confidence in her and in her ability to sort of understand the various perspectives and the different considerations at play. So there is an interim commissioner right now, but they're obviously looking for another permanent appointment. We haven't seen any decisions come out of the commission yet with respect to applications for multiple plans, and not really sure the timing of when we will see decisions. But I'm not anticipating myself any until probably early 2023, but I'd be happy to be pleasantly surprised. The Treasury Board did submit an application. It's looking for 3 multiple plans. The justification, for those of you who are curious, is largely based on the sheer massive size of their workforce and the different communities of interest and that sort of they've got between various groups of employees. And yeah, we're optimistic, again, just because of an efficiency perspective, that they may have some success. So we'll wait to see what comes out of that one, amongst others. What else are employers doing? And then I'll move on because we're already running short on time, but is preparing for the pay equity committee process itself. There are a few employers who have already established their committees. Those who haven't are thinking right now through the logistics of doing the employee vote process, for example. How do you structure the committee itself? How many representatives do you have? What kind of parameters do you put on that? They're also starting to think about the committee, like actually running the committee, getting training materials ready. Drafting terms of reference is something I recommend to all employers because while ultimately those terms of reference will have to be adopted by the committee itself, it's certainly recommended that employers go into the process with some draft terms that they can propose for adoption, and sort of put parameters around how the committee is going to be structured, how are meetings done, where are documents held, what is quorum, those sorts of things. So important to start turning your mind to that before you actually start day one of the committee. Andrea, next slide, please. Turning to a bit of a different topic, under the Employment Equity Act, those of you who are subject to it and to the pay reporting requirements probably already know that there were updates that came into effect on June 1st, 2020. New pay transparency reporting obligations were included in the reporting requirements. And those pay transparency obligations are really meant to try and address what I'll call the raw wage gap within the designated groups, so the existing designated groups that you already report on. Next slide, please. The gaps that are addressed here on the slide. So you're looking at the mean and median differences in hourly rates, again, for the various designated groups that are captured by the Act. The big thing here to think about is that this is going to be public. So these wage gaps are going to be posted publicly. We're anticipating in the winter of 2023. And the tool that they're developing to make this information public is designed to be very interactive. So to search by employer and be able to filter for different information. So we're anticipating that there's going to be a lot of activity and commotion with employees, with newspapers, looking at these gaps. The UK has a similar obligation, and we certainly know from their experience that there's a lot of, again, publicity that comes out around these because they don't look good. And from what I've seen with employers I've worked with as well, the gaps are surprisingly large still. A lot of that is due to factors completely beyond employers' control, the tendency of women to opt out of certain types of work, to opt out, for example, of overtime opportunities because of pressures that they've got of being a young parent, whatever it might be. Again, societal factors. But it is going to unfortunately come back onto the employer. One thing, a sort of practical tip here, is to talk to your PR folks about this up front and have a strategy prepared, because you'll already know what your gaps look like from having done the analysis back in June. So getting out in front of the messaging is going to be really important, and helping to explain why, you know what, as an organization, you've got a real commitment to reducing these gaps. But at the same time, there are some things that just are sort of beyond, well, that really don't take into account the reality of the workplace necessarily. Next slide, please. I'll be very fast through here, but there is still a task force that is working on updating the Employment Equity Act more broadly, looking at different definitions that have been outdated, for example. We're anticipating the report from that task force shortly, and then anticipating that there'll be at least some of those recommendations will be incorporated into legislative changes going forward, but still anticipate that's a little bit down the road. Next slide, please, Andrea. And here I'll be very brief as well, but just to flag, again, you've probably heard from me in the past on the Accessible Canada Act. It is in force. The Act is sort of has almost like a twofold purpose, the way I think about it. One is to actually include legislative requirements in the Act itself, but it also then establishes this Accessibility Standards Canada organization that develops standards. And Andrea, if you can go to the next slide, please. You'll see its mandate is largely to develop standards that then can be adopted into regulation at a later time, if appropriate. And they also take on a real sort of advocacy of sorts and educational role, similar to what we saw in Ontario with the Accessibility for Ontarians with Disabilities Act. But they're working right now actively on developing some of the standards, which again, we anticipate will eventually, at least in part, be adopted into regulations. Next slide, please, Andrea. These are the standards that are currently under development. The built environment one was just announced very recently, and they're expecting it to be published in 2023, but it is currently under consultation. The sorts of things that are covered by that are things like the banking sector should be particularly interested, or financial services, because it involves a lot of details around ATMs and interactive terminals. But you'll see again that there are a whole host of other things that they're currently working on developing standards for. They have excellent web resources, I find. So if this is an area that you're particularly interested in, go to the website and of the Accessibility Standards group, or Accessibility Standards Canada, and you can find a lot of this information about what they're working on and what's anticipated drafts of various things for comment. So the challenging part from a legal perspective of this legislation is that it's really different standards and different requirements and different timelines apply based on the industry that you're working in. Next slide, please, Andrea. And so for that reason, I won't go into too much detail about the specific timelines for any given industry, except again to know that what might apply to one industry will not apply to another. So just if you're talking with your colleagues at various federal sector workplaces, keep that in mind. Next slide, please. Some of the obligations that are currently in effect. So we've really got three. There's this obligation to develop accessibility plans, and this again is under the sort of general legislative framework. Accessibility plans, feedback mechanisms, and progress reports. The accessibility plan, important to note that you do have to include consultation with individuals with disabilities as part of the process. And generally, again, this is going to be a sort of living document that as there are additional standards that come out, you incorporate your commitment to those standards and how you're going to actually sort of incorporate those standards into your workplace in this document. So you'll see it's got to be updated every 3 years. Next slide, please. The feedback mechanism, again, this is a tool that employers are going to have to develop to solicit feedback about how it's implementing its accessibility plan, and also just generally about barriers related to the the employer's business, both from employees and customers. And next slide, please, Andrea. You'll see that as part of the progress report, you've actually got to include information about what you did with that feedback in your progress report. And you've got to publish that progress report publicly, amongst other things. So that's sort of where we are now in terms of the requirements that we know employers are going to be faced with. For the timelines, next slide, please. Again, I've set out here that the timelines, as I mentioned, it really depends on which entity you're working in. But the initial accessibility plan for most employers, again, most large employers who are on this call, it's going to be June 1st, 2023. And then your progress report will be 2 years thereafter. Next slide, please, Andrea. But you'll see that for, again, transportation, telecommunications, and broadcasting industries, you've got a little bit different timelines, including for broadcasting and telecommunications. You'll see that your feedback mechanism actually already had to be published by June 1st, 2022. And your initial accessibility plan 1 year thereafter, so June 1st, 2023, with the rest of other large federally regulated employers. So that was a very high level overview, but happy to answer more questions after the session.
Thanks, Jackie. And just as we begin to close off the session, we wanted to highlight a few things that are on the horizon. This will be a bit rapid fire, but I think the point to take away is that there's still lots more coming out of the federal government on the legislative and regulatory front that federal employers need to keep their eyes on. We'll start with a few Canada Labour Code regulatory amendments that are on the horizon. These are proposed regulations, just proposed at this point, proposed regulations that have come out quite recently that really aren't on many employers' radars, but they're the type of thing that could have a big practical impact on individual employers' practice. The first proposed regulation is a change to the occupational health and safety regulations to the code that would require federal employers to provide menstrual products in each toilet room in a workplace, regardless of the marked gender of that workplace. So that's each restroom in your workplace you'd be required to outfit with menstrual products. Second proposed regulation is a proposed regulation that would require employers to provide reasonable compensation to employees for expenses. The regulation is extremely detailed. We don't have time to go through it now, but what it would set out basically guidelines around and some parameters around what types of expenses employers required to compensate employees for, and what reasonableness means in this context. Now, notably, it is not the case that the only factor would be whether or not the employer had approved the expense that would make it reasonable. There are a variety of other factors. Again, another proposed regulation to watch out for. Last but not least, proposed regulations concerning the information that an employer is required to provide employees shortly after the date of hire. In essence, what this proposed regulation would do is require an employer to provide employees with a written description of various aspects of the employment relationship, including things like who is the employing entity? Which corporate entity is it, assuming it's a corporate entity? What are the main duties of the job the employee's been hired to perform? What are the main compensation aspects? Things like that. So this would become a standardized requirement across federal workplaces that really would, I think, systematize some of the piecemeal information that employers already do provide, but again, creating another layer of regulatory requirement around the type of information that we provide to employees. Next slide, please. Something else that we've been watching is what's been called the right to disconnect, which, as most of you know, is the idea that employees should have a right to disconnect from the workplace, not check their email, not pick up their phone, not listen to voicemail during non-working hours. Now, this is something that has been debated and studied for years, both in Canada and elsewhere. And indeed, this is an initiative that really took off a few years ago after France introduced a legislative right to disconnect for employees. In Canada, we've had recently, earlier this year, the release of an advisory committee report to the federal government, setting out recommendations on whether or not Canada should introduce a right to disconnect. Suffice to say that the various representatives on the advisory committee reached no consensus whatsoever on things other than sort of basic standardized concepts like employees should be paid for time they spend working. Beyond that, very little consensus was reached, so no concrete recommendations. But the issue hasn't died. Earlier this year in Ontario, in the provincial context, the Ford government introduced legislation that established quasi-right to disconnect here. But it's very watered down. Essentially, what it requires is that employers have a policy on whether or not and how employees can disconnect from work and what the expectations are for being available during non-working hours. But it doesn't actually set any substantive requirements. So it doesn't say anything along the lines of employer, you must allow your employees to disconnect during these periods. Rather, the employer still determines all of the content of the way in which disconnecting from the workplace is going to work in the workplace. It just needs to be set out in a policy. What's next? Well, we are not sure. This issue is still floating around the federal government, but again, it's something that has been dogged by a lack of consensus. Hopefully, if we do see any concrete action, what we will see is something akin to the steps that the government took, which again, really just requires an employer to codify their existing policies in a written document that's available to employees. Finally, very briefly, something we've been flagging for the last year or so that is not on the radar of most federal employers. And this is modern slavery legislation that is probably going to become law within the next few months. What this legislation would do is require basically any company of any size doing business in Canada to review and provide a public report on labor practices in its supply chain, and specifically with respect to child labor and forced labor in its supply chain. So that includes both within its own operating business, but also within contractors and suppliers across its global supply chain, so not just in Canada. And the legislation will require, if it is enacted, it's going to require on an annual basis a business to go through this detailed review and report writing exercise that requires, again, public disclosure of things like the risks, labor risks in its business and its supply chain, what types of forced labor, child labor incidents may have occurred in its supply chain, and even if an incident hasn't occurred, what types of risks might exist. We'll need to provide a report on what types of training it provides to employees, what types of safeguards it has in place for contractors to ensure that they don't use forced labor and child labor, and many other things like that. Again, employers will need to make this public report available on an annual basis, and the federal government's going to have quite extensive inspection and enforcement powers to ensure that companies comply with the legislation. Interestingly enough, this is not the first type of or draft legislation we have seen in Parliament on labor practices in supply chains, but it's the first one that has not just a chance of passing, but almost certainly will pass. This bill emerged from the Senate, but the Trudeau government has committed to supporting it. It has all party support, and it will likely receive third reading in the House of Commons at some point in the next few months. And if it does, then it's going to come into force as of January 1st, 2024. So something a bit interesting for us all to watch that may have add yet another layer and a new layer of compliance obligations for you to cope with in your business.
We've got a couple minutes for questions, so I'm going to try and I see a couple here that I can knock off quickly, and then I'll turn it to you and Stéphane as well to see if you can knock off a couple. And again, we apologize in advance if we don't get to all of them, because there are lots here and lots of really good ones. Before, when I was speaking about the Employment Equity Act and the pay transparency reporting obligations, just to clarify, it does apply more broadly than just the gender wage gap. It also applies to all of the other designated groups. So that's obviously women, Aboriginal people, which is not my terminology, but the terminology currently used in the Act, persons with disabilities, and members of visible minorities. So for each of those groups, you've got to report on all of those different wage gaps. I can take another one quickly. There's a question about the job evaluation process in place and whether, if you've got an existing one, the extent to which you've actually got to share details of that process with your committee. And certainly the entire framework of the Pay Equity Act is really intended to be a collaborative approach. So it's supposed to be a joint exercise between the employer and the employee representatives, whether they're union representatives or non-unionized employee representatives. So there is an emphasis on disclosure and transparency within that committee to ensure the ultimate goal of closing the wage gap is reached. So all that to say, yes, the committee members do have a right to see information that would be required to do their analysis, which would include more details of the job evaluation plan, because they've ultimately got to be able to endorse the existing job evaluation tool and the resulting values that are ascribed by that tool if they're going to be able to sort of support it and use it for the pay equity analysis. Stéphane, are there some for you that you want to pick off quickly?
I see that Stéphane has actually picked off quite a few in the rich while we've been talking. Maybe I'll take one that it doesn't look like.
Yeah, go ahead.
Hasn't been answered, which relates to paid medical leave and how much must be paid. And this question deals with employees who are working, I guess, an irregular schedule of 4 days at 10 hours a day. Question is, does this mean they get 10 days of 10 hours per day for medical leave? And the short answer is yes, unless you've established a different scheme in a collective agreement to calculate pay. But bottom line, you get paid, if you are an employee taking statutory medical leave, you get paid 100% of your wages for your regular day of work. So if your regular day of work is 10 hours, then you are earning 10 hours for your day of paid medical leave.
Stéphane, you want to take us
No,
out?
well, it's just that on this one, because there was also another question, just to make sure we cover the whole the whole subject on this type of schedule. Obviously, the situation is different for those who are working part-time, because if you are working part-time, then it refers to the provisions of the regulation, and then it's going to be like 1/20th of your pay of the last 4 weeks. But you were right, Chris, that when it's 10 hours a day, that's what you're entitled to. It's only for those who have hours that varies from one day to another, where there's going to be a difference.
Thank you, Stéphane. And I see we are right at time, and I'm sure everyone's about to jump on another call. Thank you so very much for sticking with us this afternoon. We're very privileged to work with so many wonderful federal sector employers, and we're really delighted you're able to join us. Please check out our website, the Fasken website. Look for Fasken Institute, where we'll keep updating future seminars, because we're about to roll out our 2023 seminar calendar. So stay tuned for more details, and thank you very much again.
Thank you.